Hello friends, in the series on the income tax cases, today we will discuss the case of Ravinder Kumar AGGARWAL versus Income Tax Officer. This case has been reported in 451 ITR at page number 100. The matter has been decided by Delhi High Court and the date of the judgment is 17th November 2022. In this case, three provisions of the Companies Act has been discussed. Those provisions are section 248, 250 and 252 of the Companies Act 2013. The facts of the case are like this. In this case, the name of the company was strike off from the Registrar of Companies under section 248. After the name has been taken out from the registrar, the Income Tax Department issued the notice for the assessment year 12-13 to the company. The company filed the writ petition by saying that this notice is not valid because it has been issued to a non-existent entity. This was the plea of the assessee, because there are a number of the cases which says that if the notice has been issued in the name of a dead person, if the notice has been issued to a company which has already been amalgamated, then those notices will not be valid. There is a very important celebrated case of Maruti Suzuki which helps the contentions of the assessees in those cases. But the facts of this case are a little bit different. The plea of the department was that there is section 250 which says that even if the company has been strike off under section 248, even then the liability of the company will exist as it is, as they were before the name of the company was strike off from the Registrar of Companies. In this case, the department also filed the application before the NCLT for the restoration of the name of the company under section 252, and the NCLT revived the company under section 252. There is another provision in section 252 of the Companies Act which says that if the company is revived under section 252, then the effect of this revival will be this, that this company will be revived from the date on which the company was strike off. So it means that the notice was valid because the company has been revived from the retrospective effect. So it cannot be said that on the date of the notice, the company was not in existence. Friends, the facts of this case are a little bit different from those facts in which the notices are issued to a dead person or the companies which have already been amalgamated, because there are unique provisions of section 248, 250 and 252 of the Companies Act which revives the company from the date when the company has gone from the registrar of the companies, meaning thereby that the name of the company has been strike off. So friends, by taking the help of this decision, we can draw a conclusion that in all those cases where we are planning to go into the writ on the plea that the notice has been issued in the name of a non-existent company, in cases where the name of the company has been strike off under section 248, so there are very less chances or practically no chances of getting the relief. So we should contest our matter on merits on those cases. Friends, at the end of this video, I want to say that before acting on any of this deliberation, please read the full judgment, because it may happen that while delivering the lecture, some facts of the case may be missing, because it is very difficult to summarize the case in 5 to 6 minutes, although we make all our efforts to give you the best. But it may happen that the facts of the case of your case and the facts of this case may be different. So you will be able to reach at the right conclusion only after reading the full judgment. And we also want to say that the purpose of our this YouTube channel with the collaboration of the Company Law Institute of India is only to give the insight to the listeners, or you can say that a kickstart to get an idea that they can take the help of these cases in their litigation matters. At the end of this video, once again, I am repeating the name of the case. The name of the case is Ravinder Kumar Aggarwal versus Income Tax Officer.